first time you've tried to surreptitiously see things that you weren't supposed to see. You indicated that there was an incident with a adult young woman in which you peered through the bathroom door and watched her showering and saw her nude that preceded this incident. So this is the first time something like this has happened in your life. Although you eventually came clean, as the prosecuting attorney has indicated, the record shows that you were initially playing along with the roommate's conclusions that someone else must be to blame because they knew your quote-unquote character and knew that you weren't capable of this. And when the camera was discovered and they found the SD card and they looked at the SD card closely and they found out that there were pictures of you on there suggesting it was your SD card, you still somehow were able to persuade them that someone must have stolen the SD card from your backpack and put it in the wall to look at them. And apparently they believed that for a period of time because that's what they told the police. And only when the police confronted them with the obvious illogical nature of that explanation did they begin to realize that no, maybe Devin deceived us. But that tells me a lot about your charm and your character and about your intelligence and about your ability to manipulate people. You had these 6 girls manipulated into wanting to blame some maintenance man at the apartment complex for what you had done. And you were going along with it. What if he had been charged? What if his name had appeared in the newspaper? What if his life had been ruined or defamed by being falsely accused of something that you had done? That bothers the court a great deal. And although, to your credit, you did eventually face up to what you did, for a time you were willing to let someone else suffer for what you had done. That's a serious matter, and that's a character flaw that, again, needs to be addressed. So the court's considered all of these factors. And after considering these factors, I'm going to sentence you as follows. First of all, on the request for a withheld judgment, I am going to respectfully deny that without prejudice at this time. I'm willing to take another look at that if you successfully complete the sentence the court's about to give you. But typically on sex offense cases, and in this, although you don't have to register as a sex offender, there's nothing the court can do about that because the law doesn't allow me to require that. Although you're not going to have to register, I think this is a serious enough sex offense that you need to complete probation before we even consider whether or not we should grant you a withheld judgment. The court is going to sentence you as follows. You'll be sentenced to the custody of the Idaho Department of Corrections for a total unified sentence of 5 years, consisting of a fixed minimum term of 2 years, followed by an indeterminate term of 3 years. You'll be given full credit for the 10 days that you've already served on this case. It is further order of this court, after considering all of the factors, especially those set forth in 1925-21, and given the fact and looking at this case in full context, that I should suspend your sentence for a period of 5 years and place you on probation under the supervision and direction of the Idaho Department of Probation and Parole in this court. I do think that you need help, but I think the evidence is pretty clear that that help can be provided to you while in the community without putting the public at risk. I further conclude that although this is a serious crime, it's not so serious that it requires prison as a sentence or the possibility of prison or retained jurisdiction. If you accept probation, this is going to be sex offender probation. You'll be subject to the same terms and conditions of probation that all people on sex offender probation have to comply with. They are strict and they are many, and I'm not going to review all of them at this time. But I am going to discuss some of the material conditions of your probation, and they will be as follows. First of all, given the severity of the action in this case, I don't believe that the 10 days of jail time were enough. Although it was substantial, I do think this case requires some additional jail time. The court is going to impose a total of 60 days in jail. You'll be given credit for the 10 days served, which means you have 50 days to serve. And you'll serve that immediately. Being as young as you are, I think it's in your best interest to get this over with so you can get on with your life. You'll be taken into custody at the end of this hearing. Normally on a sex offense, I do not require community service. In this type of case, though, I do think that community service can be safely done if registered in the right way, so I'm going to require 100 hours of community service. There will be a $2,500 fine imposed. Standard court costs, since this is a sex offense, will be a $375 victims relief fund paid by the court. You'll have to pay full restitution. The state will have 30 days to submit a request for restitution. That will potentially include any counseling or treatment needed by any of the 6 people in that apartment, because I consider all 6 of them victims, although some are certainly more severe victims than others. If you object to the amount of restitution or who it's allocated towards, your attorney will have 30 days after I sign the order to request an evidentiary hearing, and then the state will have to prove the restitution we're seeking. There will be the following additional conditions of probation. The defendant will not be required to register as a sex offender under Idaho Code 188307 because the way this case was charged, I cannot require it. I want the record to be clear that if I could order it, I would, because I do think that it's proper in this case, and that's perhaps something the legislature should take a look at. But the court is bound to follow the law, and the law does not require it in this case, and so I'm not going to order that. But the defendant will have 180 days of discretionary jail time. That's time that's going to hang over the defendant's head. After you get out of your local jail time, if you don't follow the rules, if I get an affidavit from your probation officer telling me you're not doing what you're supposed to be doing, or you're doing things that you're not supposed to be doing, pursuant to the terms of your probation, I could order you held for up to 180 days. You understand? Is that a yes, sir?
Yes, sir.
Additionally, the court is going to order that you be placed on sex offender probation. There will be various terms of that. I'm not going to list all of them, but they will include the following: that you are to view no pornography or any movies that depict human nudity. You are to possess no device with internet capacity or access unless it's approved by your probation officer. And you're to have no devices in your possession with video recording capacity. Now, I understand in this day and age it's difficult to get by without a cell phone, and a lot of cell phones have cameras, so you'll have to find one that doesn't. And you'll have to find one that doesn't have internet access. So no smartphone for you, but there are options that will be available. The court is going to order that you receive and complete a sex offender treatment, and that you undergo further psychological testing, counseling, and treatment as indicated in your GAIN report and the psychosexual evaluation. If any medications are prescribed for you, you will need to follow your doctor's orders, which means you're to take no more or no less than is prescribed. You're to obtain and maintain full-time employment, but I will make an exception, and that's this: if you get enrolled in college, then I'm not going to expect you to be working full-time. I would much rather see you in college than in prison, and if you want to go to college, you don't need to be working full-time, and I hope that's a course that you take in life and continue your education. The defendant will receive cognitive-based treatment, and he's not to use, self-possess, or traffic any illegal or controlled substances. He's not to associate with anyone identified by a probation officer. At this time, you're to have no contact with any of the victims, any of the 6 victims in this case. And you'll submit yourself to random testing of your bodily fluids when requested by law enforcement, and you'll be subject to warrantless searches of your person and property by law enforcement. Now, let me just lay this out for you, because I want you to understand that the person on sex offender probation can come to your home, and they'll probably look at the computers in your home, and if they find that you've been going to websites with pornography or looking at movies that you shouldn't be looking at, you'll be in violation of your probation. You understand? You need to answer audibly, sir. Do you understand?
Yes, sir.
Now, do you understand the terms of probation that I just outlined for you?
Yes, Your Honor.
Are there any of those terms that you believe that you can't live up to?
The court, okay, in Utah, exception, will the court okay transfer to Utah?
If there's a jail in Utah that wants to take them, I'll let them finish out a sentence. It's fine, but they'll start it here, and if arrangements can be made to have that transferred, I have no objection.
I'm sorry, if I said jail, I meant the probation.
Oh, yeah. The court has no objection. If, again, if the interstate compact folks will agree to accept his probation in Utah, the court will certainly permit that to be transferred to Utah. Frankly, if he's living with his family there, I think it creates the best environment for his success, so I would encourage that, and I hope that happens. Okay. Any other questions about the sentence?
going back to the jail then, and, you're okay with if the jail is served in Utah, but you want them to start today?
We'll start the time here today. If arrangements can be made, if there's a jail in Utah that wants to take them, I'll allow them to be transferred there. Okay? Now, I need to advise you of one additional thing, sir. This was your first offense under this statute. If this happens a second time, you would have to register as a sex offender. You understand?
Yes, Your Honor.
Now, you have a right to appeal my decision. If you disagree with it for any reason, you have 42 days to file an appeal. If you can't afford an attorney, I'll appoint one for you at public expense. Additionally, you have rights under Idaho Criminal Rule 35. If you think my sentence was too severe or illegal for some reason, you have 120 days to have the court reconsider, to ask the court to